A bank builds a machine that can say no to your loan before a human ever sees your name. Then two teams arrive with two giant checklists. One is worried that the machine could fail or be hacked. The other is worried that the machine could make an unfair decision nobody can explain. Most banks react by opening two separate compliance projects. That is the expensive mistake. By the end, you will know the three controls the rulebooks share, the three questions only one of them asks, and how to build one evidence trail without pretending the laws are the same. Start with the root question. DORA is the Digital Operational Resilience Act. It is the EU rulebook for keeping a financial firm's technology reliable when things go wrong. The EU AI Act is the rulebook for making artificial intelligence safe and trustworthy where it can affect people. So they meet inside one bank system, but they are not twins. DORA asks whether the technology stays available, secure, and recoverable. The AI Act asks whether an AI decision is properly governed, traceable, and watched by a human. Take one illustrative case. A bank uses an AI-supported creditworthiness model. The model pulls customer data, gives a score, and a loan officer can accept or override the recommendation. That single system is technology inside a financial firm. So DORA matters. And creditworthiness evaluation of natural persons is named in the AI Act's high-risk list, so the AI Act can matter too. This is the point where a spreadsheet of regulations turns into one real system that somebody has to operate, monitor, and explain. Both rulebooks punish the same lazy beginning, not knowing what is actually in production. DORA requires a documented ICT risk management framework that protects information and technology assets. The AI Act requires high-risk systems to be documented, logged, and managed through their lifecycle. For our credit model, the shared starting evidence is an honest system record. What data enters, what model version runs, who owns it, what vendor sits underneath, and which business decision it can influence. One reliable record can support both conversations. Two incomplete records cannot. Next comes the trail. DORA expects firms to identify, protect, detect, respond, and recover from technology risk. The AI Act requires automatic logging for high-risk AI systems, so their operation can be traced. In our case, a useful evidence trail can show the model version, the input path, the score, the human override, and any service outage. That does not mean one log magically meets every rule. It means a well-designed trail can give cyber teams, model teams, and auditors the same reliable starting point instead of three competing stories. Then comes the part no dashboard can solve. DORA makes the management body ultimately responsible for the firm's ICT risk management. The AI Act puts defined responsibilities around the people who provide and deploy high-risk AI, including human oversight for the system. In the illustrative loan case, someone must own resilience, someone must own the model's decision risk, and the people using it must be able to intervene. A single governance forum can see the whole picture, but it still needs clear named owners, not a committee-shaped fog. Here is the line banks cannot blur. A perfectly resilient system can still make a harmful decision. DORA is about operational resilience and ICT risk. It does not answer whether training data produced unfair outcomes, whether the intended use is appropriate, or whether a person affected by a decision can receive a meaningful explanation. Those are AI Act questions. Get this wrong and a bank builds an excellent cyber control pack, then discovers it never gathered the evidence needed to defend the decision itself. For high-risk AI, the AI Act goes further into the system's behavior. It calls for lifecycle risk management, data governance, technical documentation, human oversight, and appropriate accuracy, robustness, and cybersecurity. DRA already gives a bank a strong home for technology risk, incident response, and third-party oversight, but it does not replace the AI-specific evidence about bias, intended purpose, model performance, and human intervention. Think of DRA as the building's fire system. The AI Act also asks whether the person making the decision inside the building can be trusted. This is the useful legal twist. Article 9 of the AI Act requires a continuous risk management system for high-risk AI. But Article 9, Paragraph 10 says that where a provider is already subject to internal risk management requirements under other EU law, Those AI risk management aspects may be part of or combined with those existing procedures. That is permission to design one coherent framework, not permission to delete the AI specific work. For a bank, DORA can be the strong operational spine. The AI Act supplies the decision risk controls that must sit on it. Here is the practical test. First, can we point to one owner, one system record, and one evidence trail for this AI use? Second, does that trail cover both the technology failure story and the decision harm story? Third, when the model changes or a vendor fails, does one incident process tell us which DORA duties, which AI Act duties, or both might be triggered? If the answer is no, the problem is not that you need more meetings, it is that your controls were designed in separate rooms. DORA and the AI Act meet in the same bank AI system, but they protect against different failures. Reuse the foundations, the inventory, logs, owners, vendor evidence, and incident process. Then add the AI Act work DORA cannot do for you. Data quality, model behavior, human oversight, and the impact of the decision on a person. Build one coherent framework with two honest lenses. That is how teams reduce duplicate work without accidentally creating a compliance blind spot. This is the RegAI Brief, where banking regulation and AI become something you can use on Monday. Subscribe for the next 5-minute briefing and join the free RegAI Brief newsletter when the link goes live. The goal is never more paperwork. It is evidence that still makes sense when someone asks the hard question. See you in the next one.